Dear students, today we shall discuss the last important act under labor legislation, that is Payment of Gratuity Act of 1972. To continue with this, first we shall understand the meaning of gratuity. In Latin, the word gratuity means gratuitous, means a lump sum payment made by an employer as the retirement reward for his past service when his employment is terminated. So any lump sum amount that is being paid to the employee for his continuous service in the organization, so such kind of reward or payment we call as gratuity. The objective of this include as again a social security and also a retiring benefit for long and unblemished service of the person. And this act is applicable to whole India. So where it is applicable to shops and establishment covered under Shops and Establishment Act 10 or more, where 10 or more persons immediately preceding to 12 months, and once this act applies, continue to be governed irrespective of number of persons, and it shall come into force on such date as the central government may be by notification or appointment. And here we have to know the meaning of certain terminologies like employee. We know an employee means who holds a post under central or state government or who is working in any establishment. And an important condition here is a continuous service, means an uninterrupted service which may be interrupted on account of sickness, accident, leave, absence from the duty without leave, or not being treated as break in service. That is any leave that is been taken in this regard is not considered as a break, so that also will be considered as a continuous service. Or any kind of layoff, strike, lockout, or cessation of work not due to the fault of the employee also will not be considered as a break. Whether such uninterrupted or interrupted service was rendered before or after the commencement of the act, so that will be considered. And if an employee is not in continuous service within the meaning of class 1, he shall deem to be in continuous service. So that is for a period of 1 year, where certain exceptions are there. Suppose if the employer worker is working or has worked for 190 days, that is if the employee was employed below the ground in a mine, so that will be considered as a continuous service. That should be for a period of 190 days. And 190 days if the employee was employed in an establishment which works for less than 6 days in a week, and 240 days in any other case. So under such exceptions the continuity of work will be taken into account. And for a period of 6 months, so that is 95 days if the employee was employed below the ground in mine, or 95 days if the employee was employed in an establishment which works for less than 6 days in a week, or for 120 days in any other case. So this is under section 2A will be considered. And with respect to payment of gratuity, gratuity is payable when there is a continuous service of 5 years. Now it is been amended to 10 years, and not necessarily in case of death or disablement. In case of death, the amount shall be paid to the nominee or legal heir, and the time limit for this is within 30 days of gratuity becoming payable, and maximum amount that is gratuity payable to an employee shall not exceed more than 10 lakh rupees. Now from 2017 it has been increased to 20 lakh rupees. And compulsory insurance, it is mandatory where number of employees is more than 500 and the registration shall be done in prescribed time and in prescribed manner. The insurance shall be taken from LIC or any other prescribed insurance company. However, employer of an establishment belonging to or under the control of CG or SG are exempted from the operations of section 4A. And in case of filing a nomination, every employee who has completed 1 year of service is compulsorily required to make a nomination, that is form F. The nomination must be made within 30 days. The nomination must be made in favor of one or more members of the family, and nomination shall be void if it is made in favor of person who is not a member of his family. If at the time of making nomination the employee does not have family, the nomination may be made in favor of any person. The employee may distribute the amount of gratuity amongst more than one nominee, and the applicability can be made by an employee who is eligible for payment of gratuity or any person authorized in writing by such employee or nominee of the employee if the deceased employee had made a nomination. And the recovery of this gratuity includes, if the employer fails to pay the gratuity within the prescribed time, that is within 30 days of termination of employment, the controlling authority is empowered to issue a certificate to the collector to recover the amount of gratuity, and the employer shall also be liable to pay compound interest at such rate as may be notified by CG from time to time. The interest shall be paid from the date of expiry of the prescribed period and ending with actual date of payment of gratuity. And in case if the employer failed to pay the penalty, pay the gratuity, a penalty has to be borne, that is a penalty of 6 months imprisonment or rupees 10,000 or both in case of false statement to avoid payment, or in case of default in complying with the act, 3 months to 1 year imprisonment or rupees 20,000 or both, and in case of non-payment of gratuity, 6 months to 2 years imprisonment. So these are certain conditions that is applicable to under this act. Now let us understand the calculation of amount of gratuity under section 4. Here we use a formula, that is your last drawn salary, monthly salary divided by 26 into 15. 15 is average number of days in a month, that is taken as 15, and x is number of years of service of an employee. So the whatever the amount that is accumulated, that will be paid as a gratuity. Here 1 month will be treated as 26 days, excluding 4 Sundays, 4 days as Sundays in a month. And in case of piece rated work, there also the last drawn salary will be taken into consideration, where the last drawn wages should be equal to total wages received during 3 months immediately preceding termination or days actually worked. That is, last drawn wages shall not include overtime wages. And in case of seasonal establishments, such an employee shall be paid gratuity at the rate of 7 days wages for each season. Instead of 26, at the rate of 7 days will be considered. These are the important conditions that is applied under the Gratuity Act. Now let us understand the next important act, that is, again before that we shall understand the contribution rate under gratuity. So here, as like the provident fund, there is no contribution, no on monthly basis will be considered or has to be paid by an employer or by an employee. Why? Because it is been said that with a continuous service of minimum 5 years, so is the parameter to consider or to decide an employee liable for gratuity. So on that basis the monthly contributions won't be there by an employer or employee. Now let us proceed to the next important act, that is the Shops and Establishment Act of 1953. So this is again with the interest to protect the safety and social security of the workers working in different shops and establishments. This act has been introduced. Before that we shall understand some introduction to this. The Bombay Shops and Establishment Act of 1948 was brought into force from 11 January, that is 1949, on the basis of Mr. Shantilal Shah's committee report, and this act is a social piece of legislation of the state government enacted to prevent sweat laborers of unorganized sector. So this is to protect the workers of unorganized sectors. This act has been introduced, and also to regulate the conditions of work and employment, and therefore to secure maximum benefits to the employees working in different categories of establishments, namely shops, commercial establishments, residential hostels, restaurants, eating houses, theatres, and other places of public amusement or entertainments are mainly protected by the provisions of this act. And the Shops and Establishment Department is headed by usually the Chief Inspector Shops and Establishments, and is assisted by 4 Deputy Chief Inspectors. Here we have to know certain forms and formalities. So Form A is meant for registration, Form B is periodical renewal, and Form E is making any subsequent change with respect to name or the number of workers working or any changes that has to be brought to the notice using this form. And once the registration process is done, such establishments will be monitored regularly by the commissioner, that is the chief inspector or deputy chief inspectors. And in case of any breach of the rule, the nature of any kind of procedural lapses, not maintaining prescribed register of employment, leave register, visit book, then lime washing registers or any kind of such records will be considered as a lapse from the employer side, and the required documents has to be maintained for registration and also for the inspection, like memorandum of articles of association and premises purchased agreement, then list of directors, managers, and first bank account opening proof or bank account number details, then first income tax assessment order or PAN, date of commencement of business. So these are the important documents that need to be maintained, and the objectives of this include to provide statutory obligation and rights to employees and employers in the unorganized sector of the employment, that is shops and establishments, and also to regulate the conditions of work and employment in shops and commercial establishments, residential hotels, restaurants, eating houses, theaters, and other places of public entertainment. And the scope and coverage includes the state legislation. Each state has framed its own rules for the act that is applicable to all persons employed in the establishment with or without wages except the members of the employer's family. And the main provisions include compulsory registration of shop or establishment within 30 days of commencement of work, and communications of closure of establishment within 15 days from the closing of the establishment, and it lays down the hours of work per day and week. So this is about registration and opening and closing time. So for different establishments, it follows different timings and also working hours. Closing day, compulsorily one day has to be declared as a leave or holiday or a closing day, and employment of children or young person and women, they have to follow certain conditions, and they have to maintain the health and safety of such women or children working for such establishments, and compulsory leave record has to be maintained, and a minimum of 5 days for every 60 days leave has to be given. And certain deductions also can be made here by the employer. So in case of any deviations, failing to provide such necessary conditions, an employer has to face certain offences or penalties. An employer and manager can be punished with a fine of rupees 25 to 250, and maybe an imprisonment for 1 year. In exceptional cases only there will be small fines. So this is about Shops and Establishment Act. So with this we have completed all the major acts which comes under labor legislation, so which is very important as an employee and also as an employer we have to know. So with that objective, this acts has been introduced, and we have to know what it is and where it is applicable. Thank you.